G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers. Welcome to the Australian Family and Fertility Law Podcast. If you're watching this on YouTube, don't forget to subscribe. We love our subscribers. Today's topic is about birthright citizenship in the US round 2. You'll remember round 1 was actually probably round 2, this is round 3. When President Trump started his first term, he talked of having an executive order about birthright citizenship, and for some reason it never started in that term. Then one of his first acts, if not his first act as president in this term, he issued a birthright citizenship executive order saying that unless a person born in the United States had a genetic mother or a genetic father who was a US citizen, that person was not entitled to US citizenship. That executive order was immediately taken to court. The courts immediately held it up and gave injunctions saying it did not reflect a constitutional practice which had been in the US, with one exception since the 17th century, that one exception being the infamous Dred Scott case where a slave was held not to be a US citizen, and that terrible decision before the US Civil War. Following the Civil War, Congress enacted the 14th Amendment, which said that anyone born in the United States, unless that part of the US was occupied or was a child of a foreign diplomat, was entitled to US citizenship by being virtue of being born there. And that provision was upheld by the Supreme Court in the 19th century, and yet President Trump ignored that. And eventually this case reached its way to the Supreme Court, having been heard just before Easter and then disposed of 6-3 against President Trump in June. And I don't know what you were doing at Easter. My life is nowhere near as exciting as some make out. It was pretty miserable weather here one of the days of Easter, and I spent some of that time reading the transcript of the hearing, and I thought he was going to lose either 7-2 or 6-3, and thus it came to be. Well, not satisfied with that drubbing, President Trump last Thursday has done it again, and this time he's got 2 executive orders, and the first executive order is entitled Continuing to Protect the Meaning and Value of American Citizenship. And he said in this, it is the policy of the United States that no executive department or agency shall issue documents recognising US citizenship to or accept documents issued by state, local or other governments or authorities purporting to recognise US citizenship regarding persons when neither parent of that person is a citizen, and any of the following applies: that either parent is an alien enemy, or either is a foreign government employee defined to include ambassadors, employed by a foreign embassy, or employed by a foreign government in an official capacity, in other words, any public servant, and persons employed by an international organisation that possess international organisation immunity, presumably the United Nations and similar organisations. Either parent of the person engaged in a commercial transaction to purchase or access birthright citizenship of the person, or engaged in fraudulent activity to obtain citizenship to include, and the relevant one being when the parents engage in a commercial transaction with a surrogate present in the United States or a territory of the United States to give birth. So that's saying quite clearly that in his view, that if you engage in what he's called commercial transaction to do surrogacy in the United States and you're not a US citizen, then your child will not be given US citizenship, will not be entitled to it. And there is another executive order, and this one is entitled Ending Birth Tourism. In this, it is said birth tourism operators use deceptive advertisements and inducements to entice foreign nationals to travel to the United States for the purpose of giving birth on American soil. They promise citizenship, access to public benefits, and short-term stays in specialised facilities, hotels or rentals, but often fail to deliver on those promises. These operators coach their clients to misrepresent the purpose and duration of their travel to consular and border officials to obtain visas authorising entry into the United States. Failure to appropriately combat these schemes has resulted in thriving industries around the world that profit by enabling the evasion of American immigration laws, etc. And then talks of birth tourism, and that includes the entry of any foreign national into the United States via a non-immigrant visa for the purpose of giving birth on American soil, or any effort by any foreign national to facilitate the entry of any foreign national into the United States via non-immigrant visa for the purpose of giving birth on American soil. And then it's said that the relevant officials take appropriate action to prevent the entry into the US of, or the granting of any visa or any travel authorization to any alien entering or attempting to enter the US for the purpose of engaging in birth tourism, revoking the visa or travel authorization, permanently barring entry of any alien who enters or attempts to enter the US for the purpose of engaging in birth tourism, etc. So these two in combination can mean that for foreign intended parents, they may be prevented, even though they don't fall strictly within the scope of the birth tourism executive order, but preventing them getting into the United States and maybe permanently to be with their child, and then preventing their child being recognised as an American citizen. So this has the potential to be a wrecking ball to the US surrogacy industry. And certainly when I've been talking to colleagues in the United States, they've been working on this very hard. One would expect that there will be litigation before the courts there to try and combat this. I've already had to talk to clients who have had a child born in the United States and are in the United States currently following these executive orders. For Australians, the issue is, do you want to go to the United States now that the risk is higher there because of these actions of one person, namely President Trump, and the risk being that you may not be let in? For those who are already in the journey, then it's having to bring their child home. And unless there's something unusual, what I expect will happen is what happened during COVID. Namely, during COVID, the Morrison government said, well, no tourists are allowed here. And therefore, Australian intended parents, when they went to the US to collect their babies and bring them home, they applied for Australian citizenship for their child over there. Once granted, then obtained a passport. Typically, that process takes about 6 weeks. And once that's done, they bring their child home as an Australian citizen. I expect that that will still be the process used following this change. Obviously, Australian parents can join in on any action that might be taken in the courts in the US. But for the moment, at least, Australians, if they're there, will be able to bring their children home. The issue will be whether Australians will be able to get into the United States to bring their children home. Let's see. So we see how this plays out in the courts. And if the last executive order is any guide, then we're probably looking about 18 months before we have an answer. But we'll see what happens in the first case and then what happens after that. The Supreme Court has said in recent rulings that single judges below cannot make wide injunctions across the country unless they affect particular classes of people. So we'll see what judges and lawyers come up with to counter that and how wide-ranging those injunctions, if any, may be granted. So this is interesting and worrying from our point of view and my firm's point of view, we will move heaven and earth for our clients as we did during the pandemic. I said to my clients during the pandemic, those who had to go overseas for surrogacy and bring their babies back, that if necessary, we would move heaven and earth to help them get out and get them and their babies back. For some of them, we had to do a lot, and some not so much. But I kept the promise, and I keep the promise to all of my clients who are going through this journey now, that we will do whatever help we can to help them get over and come back with their babies. It is such a deep honour to help other people have children. I'm very lucky to do this job. So thanks for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers. This is the Australian Family and Fertility Law Podcast. If you're watching this on YouTube, don't forget to subscribe. Thanks. See you later. Bye-bye.